Morning. Mr. Soni.
Morning, Commissioner. Chairperson, morning, Commissioners. Chairperson, we have today Minister Masutu to give us evidence.
Thank you. Mr. Masutu, are you going to give evidence under oath or affirmation?
I will make an oath,
Yes.
my lady.
Will you swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you, Mr. Masuta. Mr. Nalane.
Thank you, Commissioner. Mr. Masuta, you have deposed to an affidavit which appears in the bundle before you.
That's correct.
And we know that you are partly sighted, and so you're using Braille as well in order for you to read some of the documents, correct?
That's correct.
But you deposed an affidavit on the 21st of March 2026 at Twando SAPS.
That is so.
Do you confirm the contents of that affidavit, and do you stand by the contents?
That is correct.
Thank you. So, Masuta, you've been asked to appear here to shed light to assist the Commission in going about its terms of reference, which I'm sure you are familiar with.
Certainly.
And in your affidavit, you summarize the terms of reference which we are all aware of. What I'll do is I'm going to read aloud the contents of your affidavit, but if you want to read through your Braille as well, you may do so. And then I'll ask you to comment further if necessary. Would that be in order?
It would be my pleasure, yes. Thank you.
Thank you. In your affidavit, at paragraph 3, you correctly summarize and state that on 29 May 2025, the President of the Republic of South Africa, Mr. Matamela Cyril Ramaphosa, issued proclamation notice 264 of 2025 establishing Commission of Inquiry into allegations regarding efforts or attempts having been made to stop the investigation or prosecution of the Truth and Reconciliation Commission of TRC cases, correct?
That is so.
We will deal with your profile a little bit shortly, but you were a Minister of Constitutional Development and Correctional Services at some point.
Yes, I was Minister of Justice and Correctional Services from May 2014 to May 2019. Yes.
And part of the period covered by the terms of reference would coincide with a period in which you'd have been in public service.
That is correct.
And that is why you are called here to come and testify to the extent that you know anything to deal with the Commission terms of reference.
Certainly, yes.
And in paragraph 4, you summarize what the terms of reference are. And as you say, the Commission's terms of reference require the Commission must inquire, make findings, report, and make recommendations concerning 1.1, whether, why, and to what extent, and by whom efforts were made to influence or pressure members of the South African Police Service or the National Prosecuting Authority to stop investigating or prosecuting TRC cases. And 1.2, whether any members of the South African Police Service of the National Prosecuting Authority improperly coordinate with such attempts to influence or pressure them, amongst other things. Those are the basic terms of reference.
Yes, I'm aware of them.
And then in paragraph 5, you deal with your terms as Minister of Justice and Constitutional Development. But before we deal with paragraph 5, perhaps we can deal with paragraph 6, where you deal with your professional qualifications and where you obtain them and your academic history.
Yes, I started off, maybe let me start that I went to a special school for the blind in 1972, where I eventually matriculated in 1984, having been diagnosed with eye cataracts when I was born and was hospitalized for about since I was a year and 2 months, for about 6 years, intermittently, until eventually I was referred by the ophthalmologist to a special school where I learned the use of Braille and other forms of reading and writing used by visually impaired persons. I am not blind, neither am I partially blind, but I'm actually partially sighted. And as they say in French, that the wine glass is always half full and not half empty. So I still have residual vision, which enable me to function, except that for purposes of reading, I do not drive my own car, and I only use large print at best for purposes of reading print. I was admitted at the University of Limpopo in January 1985 to study towards the degree of B. Juris, which I completed in 1988. And in 1989, I was admitted to the University of the Witwatersrand to study towards the LLB degree, which I completed in 1990, and hence the two law degrees that I hold.
And what did you do after your study at the University of the Witwatersrand?
Well, from January 1991, I was invited to establish and be director of the Disability Rights Unit at an organization called Lawyers for Human Rights, where I served for a period of 5.5 years until I proceeded to be appointed to be head of legal services at the department then called Social Welfare and Population Development, now called the Department of Social Development in Pretoria in June 1996.
And your career in Parliament and public service, how did that start?
Well, I may pause for a moment, if you allow me, and dwell a bit on my stint as head of legal services at the Department of Social Development, which preceded my election to Parliament in 1999, if you allow me. Should I go ahead?
Go ahead, you can go ahead.
Yes. When I was appointed to the Department of Social Development, it was during a transitional phase where South Africa was discovering itself as a democratic nation based on constitutional democracy. I was assigned under Minister Geraldine Fraser Muleketi, to head legal services there. And amongst the key responsibilities that I held was to see to the development of the legislative framework that facilitated transition from the erstwhile apartheid social welfare system into a system that was in conformity with the new constitutional order. Amongst others, for example, I drafted legislation that introduced the child support grant, replacing it with the erstwhile maintenance grant, which was only accessible to white children, white poor children, and replaced it, well, mainly, and replaced it with a universally accessible child support grant that was available to all poor children in South Africa. I can go on and on with some of those seminal initiatives in legislative and policy reforms prior to my elevation to the National Assembly as Member of Parliament in 1999. But maybe I should pause there.
Yes, I think we can then move to, but what we are saying is your involvement with human rights issues has been quite prominent, even as you were in the Department of Social Services.
Yes, actually, starting with my period at Lawyers for Human Rights, which I've already alluded to, I was quite involved in the advancement of the rights of disabled people, advocating for the inclusion of disability in the equality clause in our constitution, in our labor relations legislation, etc. And that exposure held me in good stead when I had to then deal with issues before me at the Department of Social Development. My assignment in particular focused on social welfare and child protection. So all legislation, litigation, etc., that related specifically to those two areas was my domain. When I went to Parliament in 1999, one of the primary portfolio committees I served under was the Portfolio Committee on Justice, chaired by former advocate Johnny DeLange MP.
Before you proceed, so just to round off, your involvement with issues of transformation is quite strong.
Yes. Actually, even before 1994, when I was serving at Lawyers for Human Rights, I was in 1993 in preparation towards takeover by the African National Congress of Government, part of the teams that were set up to understudy the legislative and policy framework that prevailed under apartheid. So in my case, and reporting to the late Mr. J.K. Silive, who took over from the late Ms. Winnie Mandela, I was assigned the responsibility to understudy the legislative framework governing social development at the time, or social welfare it was then called, and worked closely with Professor Vivian Taylor, who was the policy analyst, and together we formed a partnership, and we would visit the department on a daily basis to meet with the officials to study the relevant frameworks in order to prepare for the eventual takeover. And of course, when I eventually got appointed in 1996, I was already familiar with some of the issues that at hand that needed attention to facilitate transition in line with the new constitutional dispensation. And amongst others, for example, I drafted legislation that facilitated transition from the 13 administrations, the TBV states and self-governing territories, and the 4 provincial administrations, then applicable in terms of the legislative frameworks that governed social welfare provisioning, and consolidated those into a single national social welfare system, for example, under the Social Assistance Act.
Would that have been before or after your stint in Parliament?
That would have been during the time when I was heading legal services at the Department of Social Development. However, I carried through some of that work when in Parliament, I was assigned to serve on the Portfolio Committee on Social Development as well, where we basically built on that foundational work that we had done during the transitional phase into democracy. And for example, when I was in the Portfolio Committee of Social Development, we worked on the refinement of the transition of the social assistance program from the 9 different provincial administration. We nationalized it into a single national delivery system and passed legislation, the SASA Act, that also centralized the administration so that all South Africans who qualified would have the same rights, equal rights, regardless of which part of South Africa. So we took them away from the provincial administrations and centralized them in line with the constitutional mandate of ensuring that there was equal access to those social support programs.
So before you became Minister of Justice, Constitutional Development, did you have anything to do with justice in your stint in Parliament?
Yes. As I indicated, the 2 portfolio committees, my apologies, I had thought I put it on silence, or on, sorry about that. It's not responding, wanted to put it on aeroplane mode. As I indicated, when I arrived in Parliament, the 2 major portfolio committees I served on was social development and justice. And as a member of the portfolio committee of justice, we were involved in quite a number of the foundational legislative frameworks, especially those that were sanctioned by the Constitution, such as the Equality Act, and a plethora of anti-corruption laws, whistleblower legislation, anti-money laundering legislation, etc., all of which were at the time regarded as critical and foundational in building the kind of constitutional democracy that we wanted to see.
Did you, by any chance, come across any TRC case-related matters in your portfolio in justice?
Amongst the many ad hoc committees that I was appointed to serve in from time to time includes the ad hoc committee that considered President Thabo Mbeki's draft regulations for the implementation of the TRC recommendations, which report was tabled before our report was tabled and accepted by the National Assembly, effectively accepting President Thabo Mbeki's proposed regulations to give effect to the recommendations of the TRC. That is as much as I recall my involvement with TRC-related matters when I was still in Parliament, when I was still a backbencher, as it's called, in Parliament.
To your recollection, what did the regulations deal with in the main?
The regulations, to the best of my memory, and community rehabilitation, where, for example, the President determined that the amount to be payable to some 22,000 victims identified by the TRC in the form of reparation would be set, as well as the approval of the list of 22,000 that were to benefit from both reparation and all other social interventions, such as access to education, healthcare, housing, and other amenities. And of course, there was this other aspect which continued to be elusive even during my stint, and that was how best to give effect to community rehabilitation, in terms of which I cannot recall how many communities were identified, I think it was 18 or so, as particularly having suffered the atrocities of apartheid and therefore needing rehabilitation interventions, which are some of the matters that I was seized with quite closely when I took office. Of course, there were other issues arising out of the TRC that I had to deal with when I took office as well, which may or may not have directly been dealt with in those draft regulations.
Then if we may go back to your affidavit at paragraph 8, you deal with your period as when you started serving as Minister of Justice and Correctional Services. You say from May 2014 to May 2019, I served as Minister of Justice and Correctional Services.
Yes. There's so much to say. 5 years is quite a long time. I was, as they often taunted me, colleagues, that I was thrown in the deep end and had a few hot potatoes to handle when I took office. Amongst the more prominent of these was that 2 days into office, I was slammed with a court order from the North Gauteng High Court requiring me within 30 days to consider a certain Mr. Eugene de Kock, often dubbed Prime Evil, because of the atrocities that he was associated with during the days of apartheid. And in considering his application for parole and going through his profile being a record, the entire a record of your entire stay at correctional services from the first day you are admitted until the last day you leave correctional services, I noticed something strange in that profile. There was a standalone paragraph that said that the victims, the families of the victims of Mr. de Kock were consulted leading up to recommendation for his release on parole, and they all had no objection to his release. Now, what was strange about that was that there was no paper trail, no supporting documentation that supported that assertion. It was just a statement. And upon further inquiring, I discovered that around the time when the NCCS, I think it was in November 2013, a few months before I took office, the NCCS refers to the National Council for Correctional Services. It is the body that makes final recommendations to the minister when it comes to persons serving life in prison for parole, for granting or denial of parole. When I went through, so I came across a newspaper article that said quite the opposite of what was contained in that paragraph. We said that families of the victims of Mr. de Kock had rumors of, or had received information of his imminent release, and they were unhappy about the fact that they were never consulted. Now, that concerned me, and because I couldn't verify the truth or otherwise of this, I then convened a luncheon with all the 5 families. It was a hall full of probably close to 250 people, to answer a simple question, whether they were in fact consulted as stated in the profile or not. And one after the other, they all denied that they were ever consulted. And on that basis, and purely on that basis, I decided to defer his release on parole by rejecting his application initially to allow that consultation process to proceed. And it was only after that had been completed that I then granted him parole, but subject to certain conditions.
I think you deal with that a little bit more in detail at paragraph 29 onwards. But the point you make is that from day one, and I'm reading to you paragraph 29, the pagination is 1732, but the paragraph is 29. You say victim-centric approach. From day one, I prioritize victims in accountability processes. For parole of TRC convicted lifers like Eugene de Kock, killers of Chris Hani, Clive W. Lewis, and Yandus Walus, I introduced a victim-centric policy requiring consultation with victims before decisions. And in paragraph 30, you describe what you have just described now. In line with this approach, I rejected Mr. Eugene de Kock's initial application upon discovering that families of victims of his crimes were not consulted by the Department of Correctional Services and only approved his parole after proper engagement with the families of victims had occurred. You also say in paragraph 31, in addition, I made it one of the conditions of parole for that Mr. Eugene de Kock assist the NPA's missing persons task team in locating the remains of victims of apartheid atrocities. This approach extended to TRC matters like the Timor case, emphasizing victim impact. That's what you say there.
That's in essence what I was trying to refer to earlier.
Yeah.
That's correct.
Now, one of the functions which you had to be responsible for as Minister of Justice would be the National Prosecuting Authority.
That is correct.
And you deal with that in paragraph 8, the last sentence. In this role, I oversaw matters including those relating to the National Prosecuting Authority. In paragraph 9, you deal with your approach to criminal and prosecution issues. I'm going to read, then you can comment if you want to.
Yes.
My approach to criminal and prosecutorial issues, including Truth and Reconciliation Commission cases, was to await approaches from the NPA for specific action as opposed to initiation of cases. What do you mean?
Institution, the cabinet member responsible for the administration of justice exercises final responsibility for the National Prosecuting Authority, and that refers to the Minister of Justice of the day. You would also be aware that there was a so-called Ginwala Commission of Inquiry that dealt largely with the question of independence of the prosecutorial authority in the Republic, which clarified how far that constitutional injunction went and didn't go insofar as the role of a Minister of Justice is concerned. Specifically, as I would recall, that commission report, bless her soul, by former Speaker Freni Ginwala, was in essence to the effect that a Minister of Justice should not in any way interfere in prosecutorial decisions. In other words, you do not, as a minister, decide who to be prosecuted or not to, when to be prosecuted, and for what they should be prosecuted, and whether or not prosecution should go ahead. So that to me was a Chinese wall that could not be crossed. and hence I could not merimotu instruct the prosecuting authority, be it any prosecutor in any court or the NDPP himself or herself, to perform their prosecutorial functions.
And so in paragraph 10, you then say, in my capacity as a former Minister of Justice and Constitutional Development, I was not involved in the operations and daily dealings of the cases.
That is so. I did not even consider it my responsibility to micromanage the affairs, the prosecutorial responsibilities of the NPA. I had confidence in this institution and its leadership, and I believed that it was made up of men and women, well-trained, capable, who probably knew better than me how to do their work. Yes.
Then in paragraph 11, you deal with one TRC-related matter that required your specific action during your tenure, and that was that of the late Ahmed Timol. And you say, I received an application to establish an inquest into Timol's death, which was granted. You want to explain further?
Yes, actually it turned out to be just one of a few of those matters that ended up in the resuscitation of inquests to determine the cause of death for purposes of establishing who could be held responsible and therefore for prosecution to ensue. I would, in all instances, have been approached by the NPA when they were ready to do so, to request me to endorse pursuit of such inquests in that manner. And in all instances, convinced with the motivation that they gave, I had no reason not to accede to that, and indeed, that's what I did. My role specifically was confined to requesting the judge president concerned to appoint a judge to conduct such an inquest or preside over it.
You deal with that in paragraph 12, where you say, I authorize the appointment of a judge to conduct the inquest through the office of the Deputy Judge President. The decision to conduct the inquest was unsuccessfully challenged in court by Mr. Rodriguez up to the Supreme Court of Appeal, leading to the inquest and subsequent prosecution, which ended due to his passing. You want to explain further who's Mr. Rodriguez and what was his involvement?
Yes. I think perhaps I should state that one of my cardinal principles when I took office was that everyone must be accountable for their own actions, including myself. And I recall that quite frequently at management meetings of the departments I was responsible for and their entities, I used to use the phrase, black man, black woman, white man, white woman. If you follow my example, as I'm here to lead by it, I will stand right behind you. If you fall, we'll fall together. But if you do your own thing, black man, black woman, white man, white woman, you're all on your own. And this was to emphasize and make it very clear where I stood principally with regard to my approach in the discharge of my work, my responsibility as Minister of Justice and Correctional Services, that I expected nothing less of all of us to discharge our responsibilities without fear, favor, or prejudice in line with the law and the Constitution.
And then at paragraph 13, you say, prior to and post Timol's case being brought to my attention, no other TRC cases required my specific intervention. On the other hand, I have no recollection of any other matters such as the Noctula Similani matter being brought to my attention for any action during my term.
Yes. I think I need to clarify that in the case of Timor, I had to defend my decision to support an inquest in the courts, all the way to the Supreme Court of Appeal, all the way to the actual trial commencing. And I was determined to make sure that that entire process runs its course, culminating, of course, in his prosecution, which unfortunately was terminated when he passed on. In the other matters, such as
If I may just interrupt you
Yes.
there. So in the Timor matter, you authorized the reopening of the inquest after requesting by the NPA, correct?
Yes, and the manner of it was by acquiescing to requesting the judge president to appoint a judge
And
to
your decision,
initiate such,
oh,
to
sorry,
preside
yes.
over such an inquest.
And your
yes.
decision to authorize or agree to the reopening was challenged by Mr. Rodriguez.
Certainly.
And you took the matter all the way until that was resolved and the inquest reopening proceeded.
Certainly.
All right, thank you. So anything else you want to add at paragraph 13 where you say, on the other hand, I have no recollection of any other matters?
Yeah,
Including-
I wanted to contextualize to say that that does not negate what is contained in paragraphs further down, where I deal with other inquests that I authorized, namely the Hafiji matter and the Neil Agat matter, where I equally authorized the commencement of the inquest. I think the context there was essentially to say that the action that I took was to pursue seeing to, having approved the inquest, to ensuring that that decision is defended all the way through the courts until it took effect.
And then at paragraph 14, you say, I've also given approval for the reopening of the inquest into the death of the late Dr. Neil Agat in detention on 5 February 1982 at the John Foster Square Police Station. And the authorization is attached to your affidavit.
That is correct.
So you proceeded similarly, upon request by the NPA, you would approve the reopening of inquests.
Certainly.
You also did at paragraph 15 with the inquest of Dr. Hussein Hafiji. You say, I also approve the reopening of the inquest into the death of Dr. Mir Hussein Hafiji on 3 August 1977, whilst in detention at Brighton Beach Police Station. And you also attached a copy of the approval.
That is correct.
Now, in paragraph 16, you deal with briefings that you would receive now and then. I suppose as a minister, you would not just sit and wait. If there were any issues of concern to the public, it would be your duty to inquire into and ask questions about them. Correct?
That is correct.
So you're saying you knew your lane, you couldn't tell them what to prosecute, what not to prosecute, but you could certainly question them if there were issues that concern the public.
And that concerned me. If I found something untoward in my estimation, I of course would avail myself of the opportunity to probe further, for clarity's sake at least. And provide some guidance at best without seeking to direct the NPA what they should do and how they should do their work.
In paragraph 16, you say, I received general briefings on NPA matters under the NPA Act as and when needed. I became aware that during 2013, before I was appointed Minister of Justice and Constitutional Development, the matter of Similani was brought to the attention of the National Prosecuting Authority and addressed by my predecessor.
That is correct. I am aware that Mr. Sean Abrams, or Advocate Sean Abrams, during his tenure as the National Director of Public Prosecutions, did brief me about the interactions that had occurred or were occurring between himself and the affected families. And I think there were court applications to compel either an inquest or a prosecution to take effect at some point. But my sense was the matter was in hand and the NPA was well in its position to pursue the matters. It does appear that an attempt was made to proceed with actual prosecution in that instance and not have to go through inquests, if my memory serves me well. But unfortunately, because of the complications, I don't know whether it had to do with legal representation for the accused, etc. In the interim, as they say, the wheels of justice grind very slowly, and sometimes they weigh too slow for justice to eventually prevail, because my understanding is that some of those accused persons eventually passed away whilst those tussles were still ongoing.
Okay. And you describe your general approach at paragraph 17. You say, my general approach to criminal matters or matters relating to the National Prosecuting Authority was to wait for them to approach me regarding anything that required my attention, similar to what transpired in the Timor matter.
Yes, that is so. As I mentioned earlier, I always understood my role in as much as I needed to constantly appraise myself of matters broadly in the prosecutorial space as dealt with by the NPA. I, however, believed it was not my province to identify which matters needed prosecution, when those prosecutions needed to occur, and all other attendant matters associated therewith.
And you explain that further at paragraph 18, where you say, I would not under any circumstances matter more to initiate a process relating to any prosecutorial matter, be it a TRC related case or any other matter. Just to pause there, use a big Latin word, matter more to. You want to explain to?
Yes, matter more to referring to out of my own initiative. So I was not the prosecuting authority. I exercised overall authority over it, but that did not extend to me usurping their role and taking over their function.
Yes. Because then you then explain in the same paragraph, my responsibility as a minister was to the extent necessary that I would request a written or oral report on any matter I consider significant or necessary for me to receive a briefing. From time to time, I would receive briefings on different matters.
Yes. Yes, that was ongoing. It happened quite often. especially when it related to matters which the NPA would consider to be of significant public interest, especially those that involved high-profile persons. I myself, from time to time when within my own province referring to my own competence, legal and constitutional competence, had to make decisions in the course of the administration of justice of similar weight. I would often seek audience with my principals, my principal of the time, of the day. Principal is the language we use in the public sector, referring to the head of state and the head of government, the president, to brief him. In both instances it was a him, from briefings from the NPA or emanating from the discharge of my own responsibilities relating to the administration of justice. So yes, those briefings did happen quite frequently, and they were often case specific. And the idea was to make sure that before some such matters found their way into the public arena, at least I am made aware, as well as understand what was essentially going on. And like I said, where it was necessary, I would in turn brief my principal accordingly.
At paragraph 19, you deal with a specific briefing or report memorandum that was given to you by the then NDPP advocate Sean Abrahams. I'm going to read to you, just refresh your memory, what you say in this paragraph, and then we can look at the memo, and then you can comment further. You say, I was recently made aware of the existence of a report/memorandum dated 15 July 2015, signed by the then NDPP advocate Sean Abrahams, regarding TRC investigations and prosecutions. I noted that the said report, although addressed to the former DG, Ms. N. Sindani, the Deputy Minister, Mr. J. Jeffrey, and me, was not signed by all those cited. I first saw this report recently among the department documents requested for this inquiry. And if I may direct the attention of the Commission, the memorandum is marked as is SK3, but is right there at the end of the bundle. It was lifted from the evidence of Advocate Sean Abrahams, and it still bears the pagination in that bundle, which is page 84 of the. So just explain this memorandum, how it came about that you are given this memorandum.
And perhaps to give a fuller context, we may want to look at my paragraph that follows, 20 and 21.
Yes.
And if you could perhaps just go straight to 21.
20, you say, I've had sight of the affidavit of Advocate Abrahams dated 12 December 2025 for the purpose of this commission. He refers to a ministerial memorandum dated 15 July 2015, which he says was pursuant to a section 33(2)(a) of the NPA Act in relation to the investigation and prosecution of matters emanating from the TRC. Then 21, you say, I do not recall having had sight of the memorandum which lacks my signature. As appears from the memorandum, it was merely for my noting by myself. It stated that I would be informed of the outcome of the individual cases once the investigations had been concluded and decisions made on them.
Yes, and of course, in due course, I suppose you would be going into that memorandum itself.
Yeah.
The context is this. Soon after Advocate Sean Abrams took office, I think around July 2015, one of the very first briefings that he gave me related to the legacy of TRC prosecutions or matters. And of course, the context was that at the time there was much talk in the public space about lack of movement in pursuit of some of those cases over the years. So, as you can see from that annexure, the memorandum, which bears only his signature, although it purports to be a submission to myself through the various functionaries, the Director General of the department, the Deputy Minister, then Mr. Jan Jeffrey. In large measure, it gives a historical account of how the approximately 400 cases that were identified for possible prosecution, in respect of which amnesty was not granted by the TRC, never saw the light of day in the form of them ever reaching the doors of the courts. And he gives the whole expose of the circumstances surrounding that, which is something that can be talked on a little on, but in the end, he states that only approximately 8 matters were left to be considered for prosecution at the point in 2015 when he gave me the briefing. Now, that memorandum never came through the system. What happened is that we had a one-on-one briefing in which he went through the content therein, more or less along the lines that are contained in it. And in my estimation, not much turned on it. Essentially, all it said was that much of the proverbial horse had bolted, in the sense that where we were at, most of those matters was water under the bridge. And gave a whole elaborate explanation as to what led to that. And yes, it may well be that he shared a copy of this memorandum with me, but it wouldn't have been in the formal manner as prescribed in the legislation, because even though it was intended to come through in that manner, it never proceeded. Reason being that, if I recall well, he indicated that a lot of the content therein needed further reflection, further investigation, further refinement, short of just paraphrasing his explanation, and that he would come back to me on a future date after, because he had just taken over the role of National Director of Prosecution, and I believe the report would have, in large measure, have been put together by various functionaries within the NPA for his signature. So we didn't take matters further at that point, but what subsequently happened thereafter is that I received regular briefings on specific matters that could be pursued, that needed to be pursued in some form or another. Not only TRC, of course, but including TRC matters. And as it were, that's more or less what ensued going forward. And of course, in the earlier paragraphs that you alluded to, there were specific matters indeed that came to the fore. And you would notice there in the annexes that you referred to earlier, where authorized various resuscitations of inquests, that those memos would be signed by several functionaries directed at myself for approval, for decision. Because ordinarily, memoranda, or what we normally refer to as submissions, be they ministerial or DG submissions, would be generated and put through the system to facilitate decision making. So each of the cited functionaries would peruse the memorandum, be advised by those competent to advise them, and if they wanted to make any remarks or add some advice for consideration of the person destined to make the final decision, in this instance it would be the minister, they would have had that opportunity. And of course, the minister would then take account of such advice and make the necessary decision. So that memo never went through that process. And that's what I was referring to earlier when I was saying that in my document,
Thank you.
such a memo never came through.
Chair, I see it's 11:03.
Yes.
Would it be a convenient time to take the tea
Yes.
break?
We'll take a tea adjournment and reconvene at 11:15.
Thank you. Yeah.
Yes, Mr. Nalane?
Thank you, Chair. Mr. Masuta, you made the point that you did not sign this briefing note or memo, correct?
Yes, that's correct.
And you said it didn't go through the various protocols of approvals before it comes to you as the last person in line.
And as the
I'll read to you page 106, 107. This is a part of the memorandum. It's now SKA3. And I'll just read to you what I'm sure you. It just shows your names. Says Advocate S.K. Abrahams, no signature. M. Ms. Sindani, Director General for Justice and Cultural Development, noted but no signature. And then 107, Mr. J. Jeffrey, MP, Deputy Minister of Justice and Cultural Development, date no signature. And then your name is the last one. T.M. Masuta, MP, Advocate, Minister of Justice and Cultural Services, no signature. That's the point you make.
precisely.
Yeah. If you
Counsel.
yes, thank you. If you contrast that to the request for reopening of inquest, they are attached to your bundle. I think initially you had attached them as MM1 and MM2 to your affidavit. But they are now
That's correct.
referred to as annexures G, from G onwards. And I'll just refer you to or if we start at Annexure A, it is the reopening of the inquest, deceased Dr. Neil Agat, death in detention, John Foster Police Cells, Johannesburg, date 5 February 1982. And it says to T.M. Masuta, MP, Advocate, Minister of Justice and Correctional Services. So this was directed to you.
That's correct.
And it says at the bottom of that page, from Advocate S. Batohi, National Director of Public Prosecutions. That's where it would have emanated from, this request to reopen.
That's correct.
And if you turn the page, it's marked B, it says root form. Component Office of the National Director of Public Prosecutions, subject reopening of inquest, deceased Dr. Neil Agat, death in detention, John Foster Police Cells, Johannesburg, date 5 February 1982. Then you have got names of officials there. It says drafting officer, Advocate S. Bukau. You remember who Advocate Bukau was?
I must confess that I wouldn't have a good recollection of all the names of the many officials at different levels.
But she wasn't official.
Sorry.
She wasn't official.
Yes, I would imagine that she.
Title, it lists Advocate as Batohi, and there's a room for a signature and date, and then DG, DOJ, and CD, V. Matonzela Esquire, and Matonzela signed.
That's correct.
And then Deputy Minister J. Jeffrey also signed.
That's correct.
And that document would be accompanied by a document which appears as Annexure C, which is like an explanatory note to you. It talks about the purpose of the memorandum to request the minister to, in terms of section 17A1 of the Inquest Act 58 of 1959, to appoint the Judge President, Gauteng Division, to appoint the judge that the inquest in respect of the above matter can be reopened.
That is correct.
It gives a background, and then at the end, at paragraph D, there's a recommendation. And then paragraph page D, paragraph 10, I therefore request you in terms of section 17A1 of the Inquest Act 58 of 1959 to appoint the Judge President to designate a judge to reopen the inquest. Attached here with as Annexure A, a draft letter to the Judge President for approval. Kindly provide me the copy of your letter to the Judge President. And it appears there that you signed on the 23rd of April 2019.
That is correct.
And accompanying that note would be a letter which appears at Annexure F to the Honorable Judge President, Gauteng Division, asking that a judge be appointed to head the inquest.
That is so.
And you signed that letter as well to the Honorable Judge President.
That is correct.
So that is how you deal with matters that requires your approval or action, at least from you.
That is correct.
And so the note, the memo from Advocate Sean Abrams did not require any specific action to be taken on your part.
Apart from agreeing to approaching the Judge President to appoint a judge to preside over such an inquest, and effectively requesting me to endorse the decision of the NPA to pursue an inquest in that matter.
And if we go to the one about from Dr. Hassan Hafiji, it follows the same process. It's got the same covering documents and a letter from you, as well as an accompanying letter to the Judge President.
That is so.
Now, if we may turn back to the memorandum sent to you by Advocate Sean Abrams, at the very least, what you'd have known from the briefing of Advocate Sean Abrams is that there were cases in which the TRC, post-TRC cases in which investigations and prosecutions had to happen.
That is correct.
And you'd have been told, if we look, and I'm reading from paragraph 3.7 of the memorandum, where it says, the audit process, however, identified 400 cases which were in the main disposed of on the following basis. It summarizes the basis on which they were finalized. You'd have been aware of the briefing to that effect.
That is so.
Then he says to you at paragraph 3.9, paragraph page 91, approximately 350 of the 400 cases were finalized on the above basis. In respect of the remaining 50 further investigations were necessary before decisions whether or not to prosecute could be taken. You testified that, as far as you know, the cases were whittled down to about 8 or so.
Yes. That
And-
is correct.
Around 8 years. And then what he tells you in paragraph 3.8, he tells you about the prosecutions that have followed. He says prosecutions are, however, initiated in the following cases: State vs. Blanche, State vs. Blani, State vs. Nivold, and 2 others. Correct?
Yes, that's correct.
And this would be out of many cases, 400 plus, that Advocate Sean would have told you about.
That is so.
I mean, by any account, the record is not very good in terms of prosecutorial decisions, successful ones.
I would support that sentiment.
Now, you as minister, of course, you know you can't interfere, but you are the. I think the term is you play political oversight. And it means you've got to ask questions where things are not going right and demand answers.
That is correct.
Did you inquire from anyone in the NPA about this clearly not good record in the prosecution of the TRC cases?
In my estimation, that briefing was me to appreciate the difficulties or the difficult position the NPA found itself in. When I took office, as I said earlier, then I think it was called DSO or Scorpions, which was the only investigative arm of the NPA that existed prior, had ceased to exist, leaving very little, if any, investigative competence within the NPA. Of course, it's my understanding that after my stint, some form of investigative competence was resuscitated institutionally within the NPA. But when I took office, the concept was the NPA was there to assist with investigations, but not initiate or conduct same, in order to ensure maximization of prospects of successful prosecutions when the matters eventually, or the dockets eventually were ready for trial. So if the police, whether failing to cooperate or simply not having the capacity or whatever constraints, which wouldn't be, in respect of which I wouldn't be intimately acquainted with, for whatever reason failed to initiate or pursue investigations, it would have been extremely difficult for the NPA to assume that role on behalf of the police and themselves, conduct such investigations, without which there would be no basis for pursuing prosecutions. And as you can see from that report, it clearly articulates the difficulties that the NPA encountered in that regard. So I had no authority over the police. Constitutionally and legally, my mandate only extended insofar as the NPA is concerned in this context. So I did not see my way clear. Those challenges, clearly, as I said earlier, the horse had bolted in large measure, and all I could do is to make sure that where the NPA confidently felt that prosecutions or inquests could be successfully pursued, that I would support that. That is as far as I could go under the circumstances.
So you say there's a correlation between the investigations by the police and the good outcome of prosecutions.
Yes, prosecution cannot occur without sufficient evidence having been gathered and presented to prosecution to enable effective prosecution. As I indicated earlier, the concept when I took office was investigation-guided, or prosecutor-guided investigations as opposed to prosecution-led investigations. And that referred to the reality that the NPA neither had the mandate nor the capability, the capacity to itself, more to initiate and conduct investigations. They relied entirely on the cooperation and the capacity of the police to pursue such investigations. That would have been the context.
If we may just know, in wrapping up, go to your affidavit. At paragraph 23, you say, I am unaware of any formal or informal complaints about delays in TRC cases during my tenure, and no policy existed nor was pursued by me to suppress TRC investigations or prosecutions.
Perhaps I should qualify that statement to say that that is in relation to the matters in hand that we identified to be within the radar the site of the NPA to pursue. And to the best of my recollection, except for Kulumani, which early on in my stint approached me raising a number of issues directly relating to aspects of the purported regulations to give effect to the recommendations of the TRC during the time of President Mbeki that I alluded to. I don't recall any other approaches directed at me in similar vein. And of course, in relation to Kulumani, I did seek audience with, well, I did indicate to them that it was not my province to reconsider or review the regulations that were promulgated by then President, which, as I said, I had served in the ad hoc committee in Parliament, which recommended their adoption by the National Assembly and suggested that any concerns they had in seeking to have the lid lifted on the caps that were set with regard to especially issues of repression, that the appropriate door to knock at would be that of the President himself. But I did brief President Zuma about that particular encounter, and I do not know if on their own they took the matter further than that. I do recall, though, that one of the questions he raised was that the entire socio-economic transformation program of the new government under democracy was in large measure aimed at redressing the inequalities and the injustices of the past. And therefore, it becomes difficult to single out any particular group beyond what the TRC did to try and prioritize them over all others who equally may have suffered in some form or another under the apartheid and colonial deprivation and atrocities, in fact.
Just
That's-
oh, sorry.
yeah.
I'm sorry. No, you can finish. I'm sorry. I missed something.
Yeah, so that is as far as I would recall my interaction in trying to convey. Like I said, I would have regular briefings also with my principals as and when matters of significance arose of public interest from time to time. And that could have been one of the issues. But I didn't take it further than that based on the fact that I had advised that this was an area which was the president's province to deal with.
When you talk about regulations, TRC, you're not talking about regulations dealing with prosecutions, investigations of cases, are you?
No, those were essentially to do with reparations and community rehabilitation envisaged
Thank you.
under the TRC recommendations. Prosecutions, as I understood them, fell within the purview of the independent institution called the National Prosecuting Authority to deal with.
And then in paragraph 24, you say, my stance was accountability for all, with TRC cases being no exception. I think
Yes, as I said earlier, my principle when I took office was all of us ultimately have to take responsibility for our actions. And I applied that principle in all aspects of my work, which was quite vast and varied. I can talk, for example, of the over 200 a month consideration of parole applications for lifers, apparently the region of 2,500 a year, where I had to scrutinize in line with the applicable prescripts whether an offender deserved the privilege of parole, which, by the way, is simply being permitted to continue to serve a sentence outside of a correctional facility. It's not intended to end your sentence.
Thank you.
And equally, I received all manner of requests for extraditions from different parts of the world. Those were some of the run-of-the-mill matters on a daily basis that I had to deal with. And in all instances, and of course the SIU would pile me with regard to matters relating to fraud and corruption cases that had to be dealt with by the SIU, that had to go past my desk. So it was a very busy office. But in all instances, the cardinal principle was always no holy cows. Everybody should take responsibility and be held accountable for whatever actions they have chosen to embark upon.
Thank you. You then said, paragraph 25, I'm aware that at some point there were discussions about an amendment to government policy regarding prosecutions that was adopted. However, I confirm that when I took office in 2014, there was no such amendment policy, and at no stage did such policy question arise. Confirm that.
That
Mr.
is so-
Nalani, is it not better where paragraphs go together to read them and then the witness can then comment? Because otherwise later on it becomes a bit of a repetition. Consider that, but carry on.
Okay. You confirm 25?
Yes, certainly I do.
Thank you. 26, you say, during my tenure, there was never an actual policy or an active attempt to suppress any pursuit of TRC cases.
That is so. I can just state that I was aware of such previous apparent attempts at seeking to shall we say, interfere with the autonomy of the NPA, to make such prosecutorial decisions. But that was something that was something of a historical matter that never arose during my stint, and certainly none of my principals, be it then President Zuma and thereafter President Cyril Ramaphosa, to whom I reported, ever at any point approached me seeking me to in any way restrain the role of the NPA in pursuing any matter, let alone the TRC cases in particular. Yes.
And you confirm that in paragraph 27, while I could request NPA reports, not briefings, I could neither direct prosecutions nor hold them. But I think that you have dealt with that.
Yes, certainly.
And then 28, my oversight focused on professionalism, querying discrepancies in processes, and also urging the exercise of due diligence to avoid creating perceptions, among others, of political targeting, often alleged in the past, but never on prosecution outcomes. So you state to your lane as minister.
Yes, and the significance thereof is that given the history of perception that prevailed before my time of perceived use of state institutions to pursue certain political interests to benefit or favor certain political groups through prosecutorial decisions, as well as perceived, other impurities that would have crept into the prosecutorial autonomy of the NPA to prosecute their responsibility without fear, favor, or prejudice, I was particularly emphatic in my interactions with the institution that under my watch, I didn't care which political interest, even in my own political party, the African National Congress, or any other political interest. There shall not be any perception created or actually effected that sought to allow political expediency and other such impurities to interfere in the independence of the NPA in the execution of its tasks. That's what I'm referring to there.
Thank you. When I asked you about, I think we're dealing with paragraph 26 during your tenure, when you said there were no attempts or actual policy to suppress the pursuit of TRC cases, you mentioned that there may have been some historical events. Do you want to explain that?
Well, the report seems to point the memorandum in question, the 2015 memorandum. Advocate Sean Abrams seemed to suggest that there may well have been such perceived or actual interferences. I cannot vouch on that. I cannot deny or confirm that because all of that related to the periods way prior to my assumption of office.
So you're referring to what our advocate Sean Abrams wrote in the memo that was sent to you?
Yes, I took note of that, but nothing turned on it in my time because those issues simply didn't arise. Any matter that was ready for prosecution had to go through the motions, and that was it.
I want to conclude, but I want to ask you if there's anything else that we may not have touched on which you think might be of assistance to the Commission.
Well, I must start by expressing my profound gratitude to the Commission for giving me this platform to give just a little bit of my story in line with its mandate. I hope I have succeeded in discharging my responsibility as per the request and invitation of the Commission to assist in the discharge of its mandate. But I should also equally take the opportunity to express gratitude for both former President Jacob Zuma and after him President Cyril Ramaphosa for having invited me to serve in the highest office in the country, that of being a member of cabinet and retained respectively. And of course the African National Congress, my political home, for having invited me and kept me representing it. Hopefully I did not do a bad job in the almost a quarter of a century stint that I served as a member of the National Assembly and Parliament of the Republic. I must also just add that when I took office in 2014, I took time to appreciate, firstly, what were the legacy projects that my predecessor was seized with, former Minister Jeff Khampepe, and others before him. There was a Vision 2000 that was developed under the first Minister of Justice, Minister Dela Omar, that defined the vision going forward that was to be pursued by the new democracy in promoting access to justice for all. And that, amongst others, included ensuring that we make sure that all South Africans have equal access to the courts, one by rolling out court infrastructure, which we did. I ensured that projects that Minister Khampepe had initiated to build high courts for Mpumalanga, Limpopo, which did not have their own dedicated high courts, were completed during my time. And we almost reached the target of building, on average, 2 courts a year in the 5 years stint that I was there, as well as roll out major infrastructure refurbishments in no less than 13 courts. And of course, Khomotso Morocco SC, present here, would recall when I appointed her to assist me in seeing to the rolling out of the new dispensation governing the legal profession itself under the Legal Practice Act, to whom I remain indebted for the support she gave me. And there were many others who supported our endeavors to really pursue Vision 2000. We ensured that every high court had at least 1 local seat to make the high court more accessible. We made sure that over 700 magisterial districts were aligned along the lines of municipal boundaries, in line with the new constitutional spatial makeup, etc. And the list goes on. So, in conclusion, I would really wish to express my profound gratitude to all those who made sure that I had the privilege of serving this country in the manner I did. And maybe to conclude, let me also thank my Creator for keeping me alive. 3 years ago, I had a heart transplant when I was left with less than a week to live after battling heart failure resulting from cardiomyopathy, and would want to seize this moment, more lives like mine was. Thank you very much.
Thank you. Those are the questions, Commissioner.
Thank you, Mr. Nalane. Ms. Moroka, any clarificatory questions?
None, Chair. Thank you.
Thank you. Ms. Ranto?
Likewise from our side, Chairperson.
Thank you. Ms. Ntambeleni?
No questions, Chair. Thank you.
Thank you. Is Ms. Nchizane?
No clarificatory questions, Chair.
Thank you. Mr. Vani?
Chairperson, we do have a few questions by way of clarification,
Yes.
as the chairperson pleases. Firstly, Mr. Masuta, I think I should disclose to the commissioners that we do have something of a prior relationship, starting with sharing a coffee. I believe it was in 2014 when you were campaigning in Norwood. We had a very interesting discussion, which I still remember today. And I think we did actually have a subsequent meeting in your office in Pretoria, although I can't recall when, on the issue of reparations. Before I commence, I should just say at the outset that the families do not regard you as a person of interest, and they make no allegations against you in relation to stopping of the TRC cases. I want to start by drawing your attention to paragraph 12 of your statement, and I'll just read the relevant section. And this is in relation to the inquest into the late Ahmed Timo. You mentioned that you authorized the appointment of a judge to conduct the inquest through the office of the Deputy Judge President. This decision to conduct the inquest was unsuccessfully challenged in court by Mr. Rodriguez up to the Supreme Court of Appeal, leading to the inquest and subsequent prosecution, which ended due to his passing. I just want to offer a small correction to that paragraph. Mr. Rodriguez didn't challenge the inquest. In fact, he was called as a witness in that inquest, but he did bring an application for permanent stay of prosecution following the inquest after he had been charged with murder. Do you recall that?
Thank you for the correction. Indeed, that is correct.
And while we were on the Rodriguez case, you recall that it was first before a full court in Johannesburg and then went up to the Supreme Court of Appeal. I was also involved in that matter on behalf of the Timo family. You also filed an affidavit, an answering affidavit in that case. Do you recall the NPA also filing an affidavit in which they essentially admitted that the NPA in previous years had been subject to interference in relation to the TRC cases?
I think I recall something to that effect, yes.
And as a result of that, both the full court and then subsequently the SCA made findings in which they lamented that occurrence and called on the NPA to conduct an investigation. Do you have a recollection of that?
I faintly recall that something along those lines was contained indeed in that finding of the court.
And perhaps we can then move to paragraph 13. You mentioned that following the Timo case, no other TRC cases required your specific intervention. And then you say, on the other hand, I've no recollection of any other matters such as the Nokutula Smilani matter being brought to my attention for any action during my term. And again, if I just want to jog your memory. The family of Nokutula Smilani, in the course of 2015, in fact, it was in May of 2015, they brought an application against the NDPP to compel a decision in that case, either to make a prosecutorial decision or to refer that matter to an inquest. You were also cited in those papers. Do you have a recollection of that litigation?
I do recall, and in my earlier testimony, I did allude to that particular. Indeed, I would have responded to the invitation to join the proceedings. I can't quite recall because in the documentation that I was provided by the department, some of those documents were not contained in the bundle that I was provided. But my general approach would suggest that I would have supported that and at least offered to abide by the decision of the court in that regard. But I stand to be further reminded.
Yes. And in fact, what happened, well, there was a positive outcome because NDPP Abrams then decided to focus on the matter, and ultimately an indictment was issued against 4 accused in 2016. And as a result, the investigation was held in abeyance. Do you have a recollection of that?
Like I said, I faintly recollect, but in my earlier testimony, I did indicate that the bit I recall was that the holding in abeyance of the litigation or prosecution, if I recall well, was in part because of the tussle around the provision of legal representation, I stand to be corrected, that had been applied for by the accused, and there were issues around the provision thereof, and whilst the towing and throwing was going on, the horse bolted there in the sense that I think the accused eventually passed on or something, but I stand to be corrected and to be further reminded. Yes.
Actually, that is correct, although that emerged in subsequent years. After the indictment, the accused did seek state support for legal representation, which was initially denied, and they did go to the High Court to get an order compelling the police to pay their legal fees. So on that score, your memory is actually correct.
Thank you.
Let's move to paragraph 16. Here you mentioned that you received general briefings on NPA matters as and when needed. You became aware during 2013, before you were appointed Minister of Justice, that the matter of Simelane was brought to the attention of the NPA and addressed by your predecessor. Would your predecessor have been Jeff Khampepe?
That is correct.
Well, I think you can accept that it wasn't fully addressed because of the application that the family brought in 2015 to compel a decision.
Indeed, that much should be apparent in those circumstances, yes.
And then let's jump to your paragraph 19. And here you make reference to the memo that NDPP advocate Sean Abrams provided you on the 15th of July 2015. And in your evidence in chief, you've described it in some detail, and you mentioned that you had a one-on-one with advocate Abrams. Now, I just want to ask the timing of this memo. Would I be right in saying that, given that the application brought by the Simelane family was on the 29th of May 2015, and this memo was dated the 15th of July 2015, that it's likely or possible that the Nokutula Simelane litigation prompted this particular memo?
It may well be so, but equally it may well be that when Advocate Abrams assumed office of National Director of Public Prosecutions, deemed it expedient that one of the tasks he needed to discharge at his earliest would be to appraise me, in particular of the subject of matters of the regarding the prosecution of TRC related cases. But I wouldn't dispute if any other consideration would have prompted him to approach me in the manner that he did early on to give me this kind of detailed briefing. Yes.
Thank you. Perhaps if we can just turn to that memo at page 92. And if I can draw your attentions to the paragraphs flowing from 3.10. And it appears that what Advocate Abrams is doing here is setting out the situation that he and you inherited. So, for example, at paragraph 3.10, he describes the struggle to get investigators, and that both the DSO and SABC were requested to investigate the remaining 50 cases, but declined to do so. 3.11, he sets out the putting the TRC cases on hold pending the formulation of special guidelines for the TRC cases, which eventually were issued in December of 2005. Another example in relation to the struggle of investigations is at 317 onwards, where Advocate Abrams points out that SABC wouldn't investigate the cases pending the outcome of the Ginwala Commission. They say the same thing in relation to taking the prosecution policy judgment on appeal, and then ultimately in 3.2.1 that the investigations would only commence after the 2010 World Cup. So I hope I've summarized those passages for you. When you mentioned the historical problems in relation to interference, would I be right in saying that you made reference to the Abrams memo, would I be right in saying it's these paragraphs that you were highlighting?
Certainly.
And if we can just pause on paragraph 319, you indicate that by that stage the number of outstanding cases requiring investigation had been reduced to 8. Now, in the context where a few hundred matters were on the books of the NPA in the early 2000s, I suppose the question has to be asked, why so few cases, and did that question occur to you at that time?
Well, it obviously did, but as he explains in his memo, the many hurdles over time, stretching over a period of over a decade, ranging from refusal to pursue investigations by, be it the police or the Scorpions, then who were the investigative arm of the NPA, etc., as well as other circumstances relating to lack of cooperation with regard to evidence necessary to provide sufficient basis to pursue prosecutions, etc. It was a whole myriad of issues, but none of those, in my estimation, arose at the time when I took office. And being given only 8 cases that were within the radar screen of the NPA to consider prosecutions and other interventions like resuscitation of inquests, I wasn't sure how I, within the confines of my statutory and constitutional mandate, I could cause any of those issues to be revisited years after they had occurred when I took office. And my focus really became to ensure that those that were in hand were pursued in the manner that indeed they were, as reflected with in the various revitalization of inquests in particular matters and subsequent prosecutions as well.
Thank you. Perhaps we can return to your statements, to paragraph 23. And here you state, I'm unaware of any formal or informal complaints about delays in TRC cases during my tenure. And I recall you saying that you wish to qualify that, and you mentioned that you were referring to matters that were in the hands of the NPA. So just by way of context, we're aware that following the Chikani matter in 2007, and then the indictments in the Nokuthula Simelane case in 2016, no inquests or prosecutions proceeded. And to be fair, there was only a small overlap with your tenure, 2014 to 2016. But would you accept that that lack of activity between 2007 and 2016 amounts to poor delivery?
Sorry, amounts to, I missed the English?
Poor delivery.
Poor delivery. Oh, sorry, I thought it's some fancy English term. I didn't hear properly. Looking overall at the circumstances described by Advocate Abrams, giving context to why there was no real movement, as you allude to, during that period, I think that you could say that there was poor delivery if you accept the explanations such as he proffers in his memo as to why some of those matters never saw the light of day. So in that context, I would say, on his own assertion, raising all the different difficulties attendant on the efforts or lack thereof to pursue these matters, you could perhaps say that indeed better could have been done to pursue some of those matters, yes.
And just in relation to your statement that you were unaware of formal or informal complaints, you've already acknowledged the Simelane application of 2015, but I can also advise you that the families of Ahmed Timal, Neil Agate, and Hussein Hafiji, they actually placed the NDPP on terms with letters threatening actions if those inquests were not reopened. To be fair to you, you were not copied on that correspondence, but were you aware that the NDPP had been placed on terms in the Timal Agate and Hafiji matters?
To be honest, I wasn't aware, and I did not understand the issues to arise in that context. My understanding was that indeed there had been approaches between the NPA and the affected families. There had been court pursuits along those lines, but in the end, my understanding was there was ultimately no resistance to pursuing the matters as per the actual inquests and prosecutions that eventually ensued. So I would put it more in that context. But if there had been initial resistance of some form or another and took a little bit of nudging, persuasion, etc., I wouldn't have been intimately involved or privy.
Do you recall receiving a letter from the former TRC commissioners? It was addressed to the president. You were copied on it. It was in February of 2019, where the former TRC commissioners asked the president to issue an apology to the victims and families for the lack of action, and they also asked for a commission of inquiry into the failure to pursue the TRC cases.
I do not quite recall, but I wouldn't dispute that that may have come up. Like I said in my earlier testimony, at any given time, there would be no less than 100 files on my desk, all to make decisions. And I gave a fair list of some, sampling some of the matters on which I had to make decisions, and that tended to be my primary preoccupation, to make sure that decisions that rested upon me are promptly acted upon, so that justice is not delayed and effectively denied. But I wouldn't necessarily dispute that such communication may have reached my desk, I suppose, for noting, as it clearly did not require action from me, but from my principal, I suppose, as I understand it.
Then if we can turn to just one follow-up in relation to the Abrams report to you. You mentioned that subsequently you would then receive updates from the NPA on these cases. Can you recall when you were updated, would you have received written memos?
The manner of it was, as I explained earlier, memos, or what we called submissions, in this case ministerial submissions, was for purposes of making decision. It was not for general information. General information was provided in the manner of briefing notes that would not come through the formal channels. They would be accompanied by oral briefings, and the notes would simply be to facilitate one following in more specific terms whatever would be the subject of those oral briefings. So I would have received briefings not only from the NPA, but from the entirety of the justice system and its various entities, as well as correctional services, of course. So briefings was my life, so to speak. So I wouldn't recall in specific terms, and briefings didn't go on file because they would have been generated from underlying source documents, which would be the real essence of what the briefings related to. So, for example, if there would be ongoing matters currently in action, or whatever the English, in the hands of the NPA, and at any point they felt the need for me to be appraised of where they are at, the records in the NPA itself would probably, in more specific terms, provide more specific information, but that would then be distilled into briefing notes to appraise me as and when that need was identified.
Thank you. Let's move to your paragraph 25, and there you make reference to the fact that at some point there were discussions about an amendment to government policy regarding prosecutions that was adopted. But you confirmed that when you took office in 2014, there was no such amendment policy, and at no stage did such a policy question arise. Do you recall that there was litigation around that earlier special policy that was struck down by the High Court in 2008?
Yes, I do recall that well ahead of my assumption to office, such litigation did occur, and that such a policy intervention was outlawed by the courts, with the consequence that it never saw the light of day beyond that. So when I took office, that issue did not at all arise.
Yes, that's correct. It was only in force effectively between 2006 and 2008. And related to that, are you also aware of litigation around a presidential program called the Special Dispensation for Political Pardons, which was to accommodate perpetrators who had not applied for amnesty, which was also struck down by the High Court in 2009, which was upheld by the Constitutional Court in 2010.
I think I do have some recollection of that as part of my acquainting myself with the history of all of this as I assumed office. But all of that, in my estimation, no longer bore any relevance at the time I took office, as those had long been rendered obsolete.
So let's turn to what you said about Mr. Eugene de Kock. That's at paragraph 30 and 31. So you've explained why you rejected Eugene de Kock's initial application for parole after consulting with the families. And you made it one of the conditions of parole that de Kock assists the NPA's missing persons task team in locating the remains of victims of apartheid atrocities. And my recollection is that he actually did assist that team to locate some remains.
It is indeed my recollection as well.
Yes. Did you ever consider making it a condition that he also cooperate with investigators and prosecutors in relation to criminal cases?
I took it as a given that since the missing persons task team was a focus project of, short of calling it, should have a better way to call it, of the NPA, which in turn was seized with the matter in hand, namely the prosecution of erstwhile apartheid atrocities, that naturally, by requesting him to assist with finding the whereabouts of the missing as a result of such atrocities, that would also assist naturally the NPA in being able to to put together the pieces of what really transpired and who was responsible and should therefore be held accountable, including possible pursuit of such of such violations by way of prosecution, amongst others. But I must say that for me, given the report from Sean Abrams, advocate, that very little was left to be pursued through the prosecutorial route, my primary focus was to at least try and bring some form of closure by helping locate the whereabouts of the remains of victims of these atrocities, to allow the families and loved ones of the victims to find some solace from their losses.
So there's a very widely held perception that Eugene de Kock was the so-called fall guy for his superiors in the security branch and the police. And those who had issued him with commands when he was at Vlakplaas have not been pursued. So the generals above him, would you agree with that perception and that concern that only he was pursued, and that there's a level of suspicion as to why his superiors did not have to face justice?
Well, as I indicated earlier, the fact that almost all the security establishments were falling over each other, so to speak, to get him into under their care. I know the police wanted him, I think the defense wanted him, and so was the SSA. It was almost like a coveted trophy. It sounded very strange to me, being somebody who is not a vetted person and therefore not privy to intelligence matters. Not that I was particularly keen to delve into that terrain. I was happy to deal with matters within my province. The rumor was that some of them wanted him to keep him close enough for their own protection against that risk of him exposing them, and that some wanted to see him gone for their own protection. Others wanted to see him gone because of his title of prime evil. And hence heavy security was deployed around him, even when he was with the SSA, to the best of my understanding. I didn't manage him directly. The Correctional Services unit dealing with parole would have interacted with SSA on an ongoing basis regarding the management of his parole, because as long as you're still on parole, you still are responsibility at Correctional Services. But he was this one exception who I do not recall any of the people that I released on parole who was dealt with in that manner. He was the only one.
Unusual indeed.
Yes.
Mr. Masuti, thank you for taking the time to be with us today. No further questions, Chairperson.
Thank you, Mr. Vani.
Thank you.
Minister, I have a question, and it arises from this memorandum from Sean Abrams. It appears to have been prepared around about July 2015. And you say that it didn't reach you formally, it wasn't sent to you formally, but you had a briefing from Mr. Abrams, I assume more or less along the lines of what was in this memo.
That's correct.
Okay. So what he does at the end of the memo is, this is now is at July 2015, in paragraph 6, he says, and he labels it matters of current concern. So I assume that during his briefing with you, he would have described some of the matters of current concern.
Yes.
Yes. And one of the issues he raises in the memo, which I want to ask you about, whether he told you about, was that even though there were only 8 cases, the quality of investigations, even on those 8 cases, were very poor. Now, does that ring a bell for you?
That is correct, Commissioner.
Okay. Now, my question is, what did you do about this? I mean, I know you say that you had no authority over SABC, but is it not something you could have addressed at a ministerial level with your counterparts in government?
Between you and me, interfaces between myself and colleagues within the cluster, the security cluster, on a one-on-one were very few and far between. It was not very easy to secure such engagements. What used to happen, of course, is that the security cluster itself had platforms through which we would meet to discuss matters of mutual interest based on a specific agenda. It wasn't a situation where you could suddenly bring up something on an ad hoc basis in that manner. Ideally, it would have been something the counterpart and pointed to. Like I said, it was not always easy. Perhaps people were way too busy with their own priorities and preoccupations, etc. But yeah, it was also very vague because it wasn't specific in what manner this occurred. There wasn't really much further articulation, even from Sean himself, in what specific detail in respect of what specific matter this was the case. So I took comfort in the fact that he had direct interface with his counterparts in the security cluster, sufficient for him to be able to pursue some of these technical glitches that he had identified. But further to that, you can see from that memo that he felt that some of these matters needed further interaction, and that in future he would keep me posted, etc. And that came through in the form of, as and when matters arose that required further updating, and in most instances, as you can see, many of them, well, some of them ended up in me eventually coming in formally to authorize pursuit of reintroduction of inquests. So the focus really was more on what action within my purview is required for me to ensure that some of these matters are taken forward.
Okay. So with respect to the quality of investigations, you took no action?
No, it was not apparent to me what exactly that related to. And if the NPA felt that I needed to take specific action, that would have come in the form of a recommendation, because I also have to be mindful of not micromanaging or interfering in the discharge of their work because they had a direct relationship with the police or any other security entities to assist in that regard.
Thank you very much.
Thank you.
Good afternoon, Mr. Masuta.
Afternoon, Judge President.
Oh, you still recognize my voice from 2019?
We visited you at maybe once or twice at different stages of my career, from the days when I was an ordinary backbencher to days when we met in heads of court meetings, etc. Yes, I do.
Yes. And also when I was Hawks Ombud and you were minister. Mr. Masuta, something that was touched on, I'm just dealing with two brief issues, is mention was made that Mr. Eugene de Kock was possibly a fall guy, and reference was made also to the security establishment. Do you recall the Civil Cooperation Bureau and how would it relate to these aspects that I've touched on? You remember the Civil Cooperation Bureau?
Faintly. I think it was one of the establishments under the security establishment during apartheid or something of that
Yes.
nature. I can't
Yes,
offhand recall in detail what it was all about.
yes. But you can't relate the two of the Civil Cooperation Bureau playing some part in possibly causing Mr. de Kock to be a fall guy. This is really the nub of my inquiry. But if you don't recall, or if you can't
I
relate-
wouldn't particularly recall that. The name of that rings bell faintly, but the relationship with Eugene de Kock, I don't recall that coming directly in my dealings with the de Kock matter per se.
Yes, but now more relevantly, you speak about President Mbeki addressing the issue of around 22,000 victims of human rights atrocities or violations, and related to reparation, possible reparation or compensation. Now, there is in our terms of reference a matter that is still alive. Let me just read it to you, 1.4. What we should also inquire into whether, in terms of the law and fairness, the payment of any amount in constitutional damages to any person is appropriate. Can you relate maybe this term of reference to what President Mbeki was addressing?
My understanding is that what President Mbeki was addressing was giving effect to the recommendations of the TRC in this relation, specifically in relation to the socioeconomic aspects such as reparation and rehabilitation to both individuals and communities, including families of victims of those atrocities as per the TRC process. I am not sure whether that aspect would necessarily relate to that to that aspect of reparations. I would imagine that perhaps what is being referred to there could have to do with any grievances that those victims who would have felt that injustice had been meted out to them by the state not doing enough to ensure that accountability was achieved in respect of some of those atrocities, be it through prosecution or other forms of holding them accountable, that such, and I stand to correction, that such calls would more relate to that context. I do not know. I am not sure. You can correct me, Justice.
Yes. For your information, is that our attention was directed to the fact that there is a matter that is before court on this aspect, but we can't simply just avoid it. It's still a live matter in our terms of reference. That's why I invited your comment on this aspect.
Yeah, I do not know, but if it relates to failure on the part of the state to act when it should have, in a manner, in circumstances which were not justifiable, whether deliberately or otherwise, for my part, really, I would say that during our stint, the best we could do was to ensure that those matters that was in hand are pursued accordingly, and I believe to a large extent that was realized, judging from some of the actions that were taken, revisiting inquests and prosecutions that ensued, for example.
Yes. No, thank you very much. Thank you, Chair.
Chairperson, may I please place on record that Advocate Dinshloku is on MS Teams and has asked if she would be allowed to ask a clarificatory question.
Yes. Ms. Ndloko?
Thank you so much, Chair. Unfortunately, I was in court this morning and I stood down. Good morning, Minister Masuta.
Good morning,
Afternoon,
ma'am.
actually.
Afternoon,
It's actually
yes.
afternoon. Yes, well, it's morning somewhere. Just a
It must
few
have been a busy
questions
day that
on
you
the-
didn't notice the afternoon coming up. I'm saying it must have been a
has
busy
been
day in
truly-
court. Yes, please.
It is. I would just have a few questions for clarification. Commissioner Gabriel has asked most of the ones we had wanted to clarify. So we'll start with what you indicated earlier about your role as the minister versus what your oversight in the NPA. During your tenure, what did you regard as the boundaries of your oversight?
As I indicate at various points in my sworn statement and in my testimony this morning, what was holy ground for me was telling the NPA who they should prosecute, why they should prosecute that person, effectively instructing them to take action, and when they should do so. I considered that to be the sole preserve of the NPA, in respect of which I had no competence. I qualify that by saying, however, whenever a sense arose that their decision to or not to initiate prosecution could be seen as deriving from extraneous influence that is outside the bounds of the law and the Constitution, such as perceptions of political interference or favoritism, or discharging any particular political mandate in complete violation of their oath of office, so to speak. Certainly, I would take strong exception there. And those would be those instances where I would put them to task. And of course, if there was an element of sloppiness, there's been cases, for example, where the NPA lost cases and they considered appealing, in many instances successfully. And I encouraged them to do that. Because very often another court does see matters differently on appeal. And that did happen. I will not point to specific cases as they largely fall outside the purview of this commission. I myself pursued the route of appeals as and when I was not happy with decisions of courts to higher courts. Other than that, I think the overall performance of their and prosecution of their mandate without fear, favor, or prejudice was the mantra that I believed had to be closely guarded and adhered to. Thank you.
Ms. Nhloko?
Frozen.
I'm off the network. I don't know what's happening.
Ms. Nhloko, are you there?
Yeah.
Yes, you may proceed.
Double Minister. Thank you, Chair. Chair, I think it's network issues where I am.
Oh, thank you very much, Ms. Nhloko.
Chairperson,
Thank you, Chair.
may we seek an indulgence to pose one question following up from Commissioner Gabriel's follow-up question?
Yes, you may.
Thank you, Chair. Mr. Masuti, Commissioner Gabriel referred you to paragraph 6, which dealt with the challenges that Advocate Abrams had highlighted. And
Are you referring to his memo?
Indeed, yes. So it's page
All right.
105. I want to refer you to paragraph 6.5
All right.
and 6.6 at pages 105 to 106. And perhaps just let me just read you the relevant extracts for your reaction. And at 6.5, he focuses on the Nokutula Simelane matter. A particular case in point is the Nokutula Simelane matter, where a formal inquest before a judge will be held. It is a fact that evidence will be led of key witnesses being dead and key evidence being unable to be located. It is only to be expected that the judge would require an explanation as to why this matter was not investigated prior to 2011. And then on the next page, he refers to the affidavits of Bekuli and Ackerman, who allege high-level political interference. And then the last paragraph, it is only to be expected that once the decisions are publicly announced and the failure to investigate exposed, that allegations will be made that government deliberately waited for all the witnesses and accused to die before giving attention to the cases. So can I ask for your reaction to those two paragraphs?
If that indeed was so, it was truly egregious for anybody in position of authority to seek to frustrate pursuit of the rule of law and accountability under the law and the Constitution in respect, and in particular in this case, of ensuring that people who cause so much harm and pain to others should be left to continue to enjoy life, whilst those who were victims of it or their loved ones who had to pick up the pieces had to endure enduring pain as a consequence. I say this because if you allow me to deviate for a second, when I dealt with the hundreds of parole applications in general matters of all kinds, I dealt with some of the most gruesome instances of the most perverted, egregious actions on babies, innocent babies who were raped, killed, of people who were robbed and killed in gruesome manner, etc. A whole host of matters. Like I said, on average, I'm told that I was dealing with about 2,500. And if you are a lifer, you are a lifer because the offense you committed must have been serious enough to warrant a sentence of life imprisonment. So for me, reflecting on the pain, and hence my mantra was, we shall drive the criminal justice system towards a victim-centric approach to criminal justice. And it was inspiration from all these atrocities, be they committed in current times or in the past, as in the case of apartheid atrocities, that inspired me to actually issue an instruction soon after I took office that in relation to parole, no single parole application shall be considered without a reasonable attempt to identify and locate loved ones or victims themselves and seek their involvement and possible consultation prior to making a decision. Not necessarily saying that that would be an automatic bar from granting anybody parole, but to make sure that the pain they went through gets to be clearly communicated to the perpetrator, with the hope that the perpetrator would show remorse. I mean, if I were to say that the reason, for example, that I denied Yanuswalu's parole up to the last day of my stint in office was precisely because I could not extract remorse from him. I could not extract a genuine repentance for the wrongs he had done. And indeed, I understand even after he left this country, he continued to say that given a second opportunity, you would do it again. And if it was within my power, I would not release any person for whatever motive that they committed a crime with that kind of attitude. And that was my approach generally. Sorry for wobbling off beyond what you had asked me to address. Thank you.
Thank you, Chairperson.
Thank you. Mr. Nalane?
Excuse me, Chair. Apologies, Chair. With your leave, since Ms. Ndloke has reportedly had network issues, she has asked that I beg your leave to ask questions on her behalf. If
Questions on her behalf?
clarification questions.
No,
to
that
the-
has never happened. We cannot allow you to ask questions on her behalf.
Thank you,
You are
Chair.
not acting on behalf of her clients.
Thank you, Chair.
Yes.
Chair, can I then ask that I do it? But the problem is that my network in Pretoria High Court is extremely bad. And that's why I just wanted the clarifications to be over and done with so that we don't have to ever apply for cross-examination of this witness.
Yes, you may proceed if you are able to, Ms. Ndlogo.
Okay, thank you, Chair. Minister, I apologize for that. Unfortunately, I am in Pretoria High Court and the network here is extremely bad. If we can then just proceed to paragraph 29 of your statement. There you refer to a victim-centric approach during your tenure. Could you kindly just elaborate how this approach informed your engagement with one TRC-related matters, but two, your oversight role over the NPA?
I believe the NPA itself embraced that approach, judging from the testimony, the bit that I could pick up of Advocate Sean Abrams himself. In fact, my instruction to the Portfolio Collective was for us to begin to look at ways in which we could do more to give expression, concrete expression to this notion. I recall that, I can't recall whether it was 2017 or so, I assembled a team even to go to the United States to explore their prison system, but in particular to look at their model of victim support, because my feeling was the criminal justice system tended to lean more towards the side of ensuring fairness in dealing with holding perpetrators of crime accountable. But I didn't get a sense that we, at this point in time, were doing enough to ensure that those that have to live with the scars and the suffering, imagine children who at a young age lose their parents because they were killed brutally and have had to live without parental support, etc. And one can go on and on. So I hope that more can still be done beyond just TRC matters. At least there is a model there to emulate in the form of the TRC recommendations that led to the kind of reparation arrangements that apply today. But what about the many other victims of violent crime who are often left to fend for themselves in circumstances where no such dedicated support is available? I believe that continues to be an ongoing challenge. But specifically in relation to the NPA, I recall that there was a victim something policy that was adopted in the early 2000s that sought to look into specifically the rights of victims in the criminal justice system. I just can't recall offhand what that policy framework was. My estimation was that it didn't go far enough and more needed to be done. I'm not sure if I can take that matter much further than that. Thank you, Commissioners.
Thank you, Minister. I can assure you that it was taken further. Ms. Advocate Singh did testify that going forward, they have been engaging with victims throughout. And then our last question on this. During your time, this question came during your interaction with Commissioner Gabriel. During your time on the security cluster, were there any discussions between you and your counterparts in relation to TRC matters and any difficulties that arise from them? I understand that you say you didn't have enough time or you didn't have one-on-ones, more especially with your counterpart from the police. But did these ever arise, and if they did, under what context?
I don't recall specifically such an agenda item coming up on those fora. My sense was that unless the NPA specifically requested in a formal manner, in very specific terms, because the manner of the workings of government is that we make decisions. We do not engage in generalities. So if a decision is to be made, that would have to be clearly articulated as a proposal with all the motivation and the possible options of interventions that could be implemented to realize the solution of the problem at hand. I did not get a sense that we ever got to that stage in dealing with the role of the other players in the system, specifically in relation to the matters at hand before the NPA, as reflected in the Sean Abrams report. I don't think that I could take it further than that.
Thank you, Minister. Thank you, Chair. That's all for us.
Thank you, Ms. Ntloko. Mr. Nalane.
Chair, no re-examination. Thank you.
Thank you. Mr. Masuta, you are the first former minister to appear before this commission, and we are profoundly grateful for you for having agreed to come to appear before this commission. For now, you are excused as a witness. We thank you for your attendance.
I thank you for the opportunity, Commissioner.
Chairperson, that is the business for the day. The next sitting of the Commission, because of certain developments regarding subpoenas and so on, is going to be on the 8th of June, Monday the 8th of June.
8th of June, at 10 o'clock.
At 10 o'clock.
Yes. These proceedings are adjourned until the 10th of June. 8th of June, sorry. I almost extended to the time of the sitting. To the 8th of June, 2026 at 10 hours.
As you please, Chair.
Thank you.